What happens when the nation's chief law enforcement officer stops serving the people and instead becomes the personal lawyer of one man? That question set the stage for one of the most heated confrontations in Congress, a clash that cut to the very core of what it means to defend democracy, the Constitution, and the rule of law. Imagine a Department of Justice that no longer acts as an independent institution, but as a weapon in the hands of a single leader. That's what Representative Jamie Raskin laid bare in a stunning moment that revealed how fragile the balance of power truly is, and why state attorneys general have become the last line of defense.
Thanks, Senator Schumer. We're going to start with questions with Congressman Raskin.
Thank you very much, Senator Durbin and Senator Schumer. Thanks for joining us and for your powerful leadership on behalf of the rule of law and the Constitution in New York and all over the country. Your citation of Senator Warnock reminds me of something that Ben Franklin said, where he said, I've observed that wrong is always growing more wrong until there's no bearing it anymore, but that right, however opposed, comes right at last. And so
Warnock paraphrased Benjamin Franklin.
Well, they were thinking along parallel lines, undoubtedly.
Thank you, Jamie.
Thank you for joining us. I want to recognize my Democratic colleagues who've joined us today: Hank Johnson from Georgia, Ted Lieu from California, Deborah Ross from North Carolina, Chuy Garcia from Illinois, Mary Gay Scanlon from Pennsylvania, and Becca Ballin from Vermont. But I just have a couple of questions for you guys. One is I want to say that when, pursuant to Senator Warnock and Ben Franklin, we get through this nightmare, and we will, and when we reclaim the trajectory of American history for democracy and freedom, and we will, all of you will be remembered by future generations for what you did to stand up for us during this time. And I don't want you to think that anybody doesn't notice, because we do notice what it is you're doing. But I want to ask you this, because in addition to the substantive defense of the rule of law and the Constitution you're engaged in, all of you are also modeling what it means to be an attorney general. Because we've got an attorney general of the United States who literally thinks her job is to be the president's lawyer and to do whatever the president wants her to do, and thinks that the Department of Justice is the law firm for the president and his political party. I mean, that's a remarkable deformation and diversion of American history. So although it's indisputable that all of you are Democrats, I don't think you're here to represent the Democrats or the Democratic Party of your state. And I just wonder if you would say a word about what it means to you to be an attorney general and to try to act on behalf of the rule of law and not a political program. Perhaps Attorney General Rowell, if you'd start.
Thank you for that question. I serve as the Attorney General of the state of Illinois, and in Illinois, I am independently elected from the governor, and by way of that, I serve the rule of law. I don't serve the governor. I do represent the governor. I represent the agencies within state, but I serve the rule of law, and I take that distinction very seriously, and I think that the U.S. Attorney General should operate with the same sort of, she shouldn't be loyal to the president, but she should be loyal to the rule of law. That does not mean you're not representing the government and the administration, but you have to do so within the bounds of the rule of law, and we take that very seriously.
Is there any one of you who would describe your job as being the governor's lawyer? Exclusively in any way, okay. So I don't know if anybody wanted to add anything else on this. Yes, Attorney General Campbell.
I'll just add, similar in Massachusetts, elected by the people, and I'm accountable to the people in upholding the rule of law and protecting their rights and protecting our state's economy. I would just stress, and I think the NIH case, which we were all a part of, whether it's the first case or even the second iteration of that case, to protect access to these critical life-saving medical research, clinical trials. This is billions of dollars that go to every state in the country. We came together not looking at, okay, how do we just protect those who are Democrats or identify as Democrats in this country? We came together recognizing the unlawful actions by this administration to cut that funding. in NIH1 quickly on a Friday night and mobilized to show up in court on Monday because we knew what was at stake. When you talk about a child having pediatric cancer or a vet dealing with PTSD, we don't look at whether or not they have a D or an R by their names. We mobilize to advance that litigation to protect the public health, not even only of those folks in our state, but to protect the public health of everyone across this country while at the same time upholding the rule of law. And I think it's just a great example of a great example of how we do our work regardless of political affiliation or even demographic.
Well, thank you for doing that. And Ellison and Plotkin, let me just twist the question a little bit. One of the things you guys are doing is defending the integrity of federal laws and programs that we've adopted. And because of the very restrictive standing rules that the court has imposed against Congress going to court to try to get our laws implemented, in a weird way, you're standing up for the laws that we've participated in passing. But that's for all of the people, because after all, it's your representatives in Congress who voted for them as well. But I wonder if you could just reflect a little bit on that role you're playing in terms of making federal law work for everybody in the country as a state attorney general.
Chairman Raskin, we regard the laws that Congress passes as fundamentally the prerogative of the people who populate this country and send members to Congress. And so for an executive to usurp the role of Congress in appropriations or establishment of agencies or anything like that, we view as an outrageous overreach that simply cannot be tolerated. As I noted in my comments, the things that the president is trying to do, you probably can do if you follow the rules, but you cannot do it vis-a-vis executive order or edict or proclamation or this is how I feel this morning. The fact is that there are procedures that they can follow. They got to go to Congress. You want to abolish the Department of Education, as horrible of an idea as I believe that is, you have to go through Congress to do that. So he's not only doing things that I think are harmful to the American people, he's doing them in a way that is harmful to our system of justice and democracy.
Great. And then finally, forgive me.
I was just going to note, Representative Raskin, that what you said at the start of this is the core of many of the lawsuits we filed. Article 1 gives this body the broadest powers, particularly when it comes to passing laws, spending money. And a bulk of the cases we have talked about and have brought have been the president. When we say he can't act like a king, it means he can't take actions that you have done and put into law, signed into law by a president, passed by a Congress, and decide on a whim that he wants to, say, convert a Department of Transportation highway program into an immigration enforcement program. That is not what the Constitution allows. And so our lawsuits have been about standing up in many ways for the authority of this body to do the important work that it does.
For the next few minutes, you're going to see how these officials fought back, why Raskin's words sent shockwaves through the hearing room, and what it means for every American who still believes in justice. Raskin did not hold back. He condemned the Attorney General's role as nothing more than an extension of the president's will, calling it a remarkable deformation of American history. His words cut through the noise like a blade, framing the issue not as politics, but as a constitutional crisis. In Raskin's view, the top lawyer in the country had abandoned her duty to serve the people and instead pledged allegiance to power. That alone would have been explosive, but what came next turned the hearing into something far greater than a political scuffle. It became a battle over the very survival of the rule of law. Sitting before him were a group of state attorneys general, leaders who operate with a completely different understanding of their office. They reminded the room that their positions are not extensions of governors or political parties. They are independent, elected directly by the people. Their mandate is to uphold the law, not to cater to whoever holds executive power at the moment. It was a stark contrast. On one side, blind loyalty to a leader. On the other, fidelity to the Constitution itself. And as each state official spoke, the tension deepened. Viewers watching couldn't ignore the question Raskin had posed. What happens when the highest federal attorney becomes a partisan shield instead of a defender of justice? But this wasn't just about abstract principles or legal theory. The attorneys general drove home that real lives were at stake. They brought up the case of the National Institutes of Health, where billions in funding for medical research was suddenly cut off. Pediatric cancer trials, PTSD treatment programs for veterans, life-saving studies that touched every state in the nation, all were jeopardized overnight. And in less than a weekend, state attorneys general mobilized, taking the administration to court to stop the damage. Their message was clear. This wasn't about Democrats or Republicans. It was about protecting citizens, ensuring that sick children and wounded veterans didn't lose the treatments they desperately needed. That kind of defense of the law went far beyond political labels. It was about human survival. That example hit hard because it connected lofty constitutional ideas to something every American could understand. A child in a hospital bed, a veteran struggling to heal, families desperate for answers. These weren't partisan issues. They were matters of life and death. The hearing made clear that when those in Washington failed to uphold their responsibility, state attorneys general stepped in, not for political points, but to save lives and preserve the integrity of law. And if they hadn't, the consequences would have been devastating. Still, the constitutional questions couldn't be ignored. The attorneys general explained how the president had been overstepping boundaries again and again, acting not like an elected official bound by laws, but like a monarch issuing decrees. From immigration policy to attempts at reshaping federal agencies, these were not small technical overreaches. They were direct assaults on the separation of powers. The Constitution gives Congress the authority to pass laws, allocate funds, and define the framework of government. Yet time and again, executive orders were being used to bypass those limits, as if one person's morning mood could redefine the law of the land. The metaphor was chilling. He can't act like a king, one attorney general declared, reminding everyone that the founders designed the Constitution specifically to prevent such concentrated power. Kings rule by whim. Democracies rule by law. That line resonated not only in the chamber but across the country because it crystallized the stakes. If unchecked, the executive branch could warp itself into something unrecognizable to the founders' vision. But here's where the battle got even more complicated. Courts have long restricted Congress's ability to sue when its laws are undermined. That meant lawmakers themselves were often powerless to defend the legislation they had fought to pass. So who stepped in? State attorneys general. They became the shield that Congress could not hold, the enforcers of federal law when the legislative branch had its hands tied. That fact alone underscored just how critical these officials had become, not only for their states, but for the survival of democratic governance across the entire nation. Raskin seized on this point, framing it in historic terms. He reminded the hearing of Benjamin Franklin's warning that wrong is always growing more wrong until there's no bearing it anymore. But right, however opposed, comes right at last. It was a moral call to arms. History, Raskin argued, was filled with moments where leaders bent or broke the law in pursuit of power, and each time it had to be confronted by those willing to stand for principle. To surrender constitutional duties for personal loyalty was not just weak, it was dangerous, even authoritarian. The hearing wasn't only about legal doctrines or political theater. It was about the survival of democratic norms under relentless pressure. By invoking Franklin, by highlighting pediatric cancer trials and veterans suffering from PTSD, by painting the president as a would-be king, Raskin and the attorneys general translated the stakes into terms every American could feel. This wasn't some distant fight in Washington. It was about whether the system still belonged to the people or had become hostage to one individual's will. The contrast could not have been sharper. On one side stood a federal attorney general accused of treating her position as the president's private law firm. On the other stood state attorneys general affirming again and again, they serve the law, not a political master. Their independence, their swift actions, and their constitutional fidelity painted them as the defenders of democracy at a moment when it seemed to be unraveling. As the testimony drew to a close, the pattern was unmistakable. Each lawsuit filed, each rapid mobilization, each principled stand against executive overreach was more than a legal tactic. It was a declaration that democracy is fragile but worth defending. Raskin's voice carried the warning. When constitutional obligations are traded for personal allegiance, the entire system trembles. And yet, the resilience of those who refuse to bend offers hope that the system can endure. The hearing ended not with calm, but with urgency. The audience, lawmakers, and citizens alike were left to grapple with a haunting question. If the Attorney General of the United States becomes the servant of one person instead of the people, who will stand up to protect the rule of law? The answer, as this hearing showed, came from state officials willing to fight in court, willing to defend Congress's authority, and willing to say no when power demanded yes. And that's the lesson. It's not just about one leader, one administration, or one attorney general. It's about whether America will remain a nation of laws or slip into a nation ruled by individuals. The stakes could not be higher, and the courage of those who resisted in this moment will be remembered long after the headlines fade. If you found this breakdown helpful, make sure to hit the like button, subscribe, and ring the notification bell. That way you'll never miss a deep dive into how power and accountability collide in American democracy, and why the fight for the rule of law is far from over.